The American legal system has witnessed a fundamental transformation in how courts evaluate restrictions on constitutional rights, particularly concerning the possession and use of firearms. Recent judicial developments have established new parameters for analyzing whether government regulations align with the nation's founding principles, creating ripples that extend far beyond any single courtroom decision. Understanding this shift requires examining not just what courts have decided, but how they've fundamentally altered the analytical framework used to assess the boundaries between individual liberty and collective security. At the heart of this transformation lies a methodological question that has vexed legal scholars and practitioners for generations. When modern societies confront challenges that didn't exist during the drafting of constitutional documents, how should courts determine whether contemporary solutions remain faithful to historical principles? This question becomes particularly acute when dealing with rights explicitly enumerated in founding documents, where the tension between original intent and evolving circumstances demands careful judicial navigation. The challenge intensifies when technological advancement creates scenarios that framers could never have anticipated, forcing contemporary jurists to extrapolate principles rather than simply apply clear precedents. The judiciary has recently coalesced around an interpretive approach that emphasizes historical continuity rather than exact historical replication. This distinction proves crucial because it acknowledges that while specific circumstances change, underlying constitutional principles maintain consistent relevance across centuries. Courts have begun distinguishing between seeking identical historical regulations and identifying analogous historical reasoning, recognizing that the former approach would render constitutional analysis impossibly rigid, while the latter preserves fidelity to foundational values, while permitting necessary adaptation. This methodological refinement addresses a persistent problem that emerged when courts initially attempted to apply historical analysis too literally, creating analytical paralysis, as judges struggled to match contemporary situations with founding-era precedents that could never perfectly align. The transition toward this more nuanced analytical framework didn't occur overnight, but rather emerged through years of judicial experimentation and scholarly debate. Earlier attempts to ground constitutional analysis in historical tradition often produced contradictory results across different jurisdictions, with some courts adopting extremely narrow views of what counted as sufficient historical precedent, while others employed such broad historical analogies that nearly any regulation could be justified. This inconsistency created legal uncertainty that affected not only litigants and courts, but also legislators attempting to craft regulations that could withstand constitutional scrutiny. The recent convergence toward a middle ground approach represents a maturation of constitutional methodology, though disagreements persist about precisely how much flexibility historical analysis should permit. One significant aspect of this judicial evolution involves clarifying who falls within the protected class of individuals entitled to full constitutional protections. The concept of responsible citizenship has emerged as a critical threshold, establishing that rights belong to those who demonstrate through their conduct that they can be trusted with the responsibilities those rights entail. This principle finds deep roots in early American legal traditions, where community membership carried both privileges and obligations, and individuals could forfeit certain protections through actions demonstrating incompatibility with civic order. Historical evidence reveals that founding-era communities regularly disarmed individuals whose conduct suggested they posed threats to community safety, whether through political disloyalty, criminal behavior, or demonstrated dangerousness. This practice wasn't viewed as infringing upon fundamental rights, but rather as acknowledging that rights presuppose responsible exercise. The implications of this refined framework extend across numerous categories of existing regulations currently subject to constitutional challenge. States have enacted various restrictions on firearm types, capacity, locations of carry, and purchase procedures, each justified by different public safety rationales. These regulations now face renewed scrutiny under analytical standards that demand historical grounding, while acknowledging that perfect historical parallels may not exist. Courts must determine whether each restriction category aligns with founding-era principles about the scope and limits of constitutional protections, even when the specific factual scenarios differ dramatically from anything the framers encountered. The practical application of these principles reveals inherent tensions that courts must navigate. Modern firearms technology bears little resemblance to 18th-century weaponry, yet constitutional analysis demands finding connections between founding-era principles and contemporary regulations. Some legal theorists argue that this gulf between historical context and modern reality necessitates focusing on broad principles rather than specific mechanical details, while others contend that meaningful historical analysis becomes impossible when abstraction levels rise too high. These competing perspectives ensure continued litigation over where courts should draw lines between permissible and impermissible regulations. Consider regulations targeting specific firearm configurations based on mechanical features. Multiple jurisdictions have prohibited certain semi-automatic rifles, arguing that particular design elements make these weapons especially suitable for criminal misuse. The constitutional question becomes whether such categorical prohibitions can be reconciled with historical traditions, when the affected firearms represent commonly owned items used overwhelmingly for lawful purposes by millions of citizens. Historical analysis reveals no tradition of prohibiting weapons based on mechanical features that don't fundamentally alter the weapon's basic function, suggesting that regulations distinguishing between firearms based on cosmetic or ergonomic characteristics rather than core functionality may struggle to demonstrate sufficient historical grounding. The widespread civilian ownership of the affected firearms becomes legally significant under doctrines protecting items in common use for lawful purposes, when tens of millions of citizens possess particular firearm types without incident. That fact itself becomes relevant evidence that possession of such items remains consistent with responsible citizenship. The challenge for jurisdictions defending these prohibitions lies in demonstrating how historical principles support categorically excluding commonly owned items from constitutional protection, simply because they possess features that some find aesthetically concerning or militaristic in appearance. This burden becomes heavier when the prohibited features don't meaningfully affect the weapon's lethality compared to functionally equivalent but legally permissible alternatives. Empirical questions about the actual effects of various regulations increasingly intersect with constitutional analysis in ways that complicate judicial decision-making. Courts must evaluate not only whether regulations have historical grounding, but also whether they effectively advance legitimate governmental interests without unnecessarily burdening constitutional rights. This requires engaging with complex social science evidence about weapon usage patterns, criminal behavior, and regulatory effectiveness. Different studies often reach conflicting conclusions about whether particular restrictions actually reduce violence or primarily burden law-abiding citizens without significantly affecting criminal conduct. Courts face the difficult task of evaluating this evidence while remaining within their institutional competence, avoiding transformation into super legislatures, making policy judgments better suited to elected branches. Another category of restrictions facing intensified scrutiny involves limitations on ammunition capacity. Several states have enacted regulations prohibiting magazines exceeding specified round counts, operating on the theory that forcing more frequent reloading during criminal attacks could reduce casualties. The constitutional difficulty these laws encounter stems from the absence of any historical tradition of capacity restrictions during founding-era America. While firearm technology certainly differed in the 18th century, no evidence suggests that communities restricted the capacity of weapons that did exist, even when higher capacity designs became available. This historical silence becomes problematic for modern capacity restrictions when courts apply frameworks demanding historical grounding for contemporary regulations. The question of whether capacity restrictions can be justified under general principles rather than specific historical precedents remains contentious. Proponents argue that the founding generation's general acceptance of reasonable regulations implies authority to restrict capacity in modern contexts, where high-capacity magazines didn't exist. Opponents counter that the absence of historical capacity restrictions despite the availability of higher capacity weapons for that era suggests the founding generation understood the right to include whatever capacity technology permitted. This debate illustrates the broader tension between analogical reasoning that permits flexibility and historical analysis that demands concrete precedential support. Geographic restrictions on where individuals may carry firearms present yet another category of regulations undergoing reassessment. Following earlier decisions invalidating subjective licensing schemes, several jurisdictions responded by dramatically expanding the list of locations where carrying remains prohibited, even for licensed individuals. These expansive sensitive place designations attempt to preserve regulatory authority by identifying specific locations where heightened safety concerns allegedly justify restrictions. But the historical analysis framework demands that such designations align with founding-era understandings of where weapons could be prohibited. Historical evidence indicates that certain specific locations enjoyed recognized authority to exclude weapons, including courtrooms, legislative chambers, and polling places during active voting. However, the historical record doesn't support prohibitions covering vast swaths of public space or establishing default rules, making carry illegal unless specifically permitted. The founding generation understood weapons as ordinary tools that responsible citizens routinely carried in public spaces, with restrictions limited to narrowly defined sensitive locations rather than broadly applied across general public areas. Modern regulations designating entire categories of common public spaces as prohibited zones face the challenge of demonstrating sufficient historical grounding for such expansive restrictions. Founding-era practice took a much narrower approach. The geographic restriction debates also implicate questions about federalism and the appropriate balance between national constitutional standards and local regulatory autonomy. Different communities face varying circumstances regarding population density, crime patterns, and cultural attitudes toward firearms. Some argue that constitutional analysis should accommodate these variations by permitting localities to adopt regulations suited to their specific contexts. Others contend that fundamental constitutional rights demand uniform protection regardless of local preferences, preventing jurisdictions from effectively nullifying rights through expansive restrictions. These federalism tensions add additional complexity to already difficult constitutional questions. Temporal restrictions on firearm acquisition represent another regulatory category, confronting renewed constitutional scrutiny. Multiple jurisdictions impose mandatory delays between purchase initiation and actual possession, justified as cooling-off periods that might prevent impulsive acts of violence or self-harm. Additional restrictions limit the quantity of firearms individuals may purchase within specified timeframes, aimed at preventing trafficking and illegal distribution networks. Both categories of temporal restrictions lack clear historical precedents, as founding-era and 19th century practice generally permitted immediate possession following purchase without quantity limitations. The constitutional difficulty these temporal restrictions encounter lies in their fundamental incompatibility with historical practice across most of American history. For the overwhelming majority of the nation's existence, firearm purchases involved immediate possession without waiting periods or quantity limits. These restrictions emerged as 20th century policy innovations without roots in earlier American legal traditions. Under analytical frameworks demanding historical grounding, this lack of precedent creates substantial obstacles for defending these regulations, particularly when combined with the recognition that purchasing multiple firearms or seeking immediate possession doesn't inherently indicate irresponsible conduct or criminal intent. Perhaps the most constitutionally complex category involves preventive confiscation systems, allowing temporary firearm removal based on predictions of future dangerous conduct. These systems operate outside traditional criminal justice processes, permitting firearm seizures before any criminal charges based on allegations that individuals may pose future threats. The constitutional tension arises because these systems remove firearms from individuals who haven't been convicted of crimes or formally adjudicated as dangerous through established legal processes, instead relying on predictions and concerns about potential future conduct. The judicial framework emphasizing protection for responsible, law-abiding citizens creates both support and challenges for these preventive systems. On one hand, the recognition that government may disqualify individuals who demonstrate through conduct that they pose credible threats provides potential justification for temporary preventive measures. On the other hand, the emphasis on law-abiding conduct raises questions about what process suffices to determine someone has forfeited protections before any formal adjudication of wrongdoing or dangerousness. Historical analysis reveals founding-era practices of disarming individuals deemed threatening, but those historical precedents involved clearer bases for intervention, such as political disloyalty during wartime, or actual criminal conduct, rather than predictive assessments of future behavior. The procedural protections accompanying preventive confiscation become critical to their constitutional viability. Systems providing robust due process protections, including prompt adversarial hearings with high evidentiary standards and strict temporal limits on confiscation duration, more closely align with constitutional requirements than systems permitting extended confiscation based on minimal evidence, without meaningful opportunity for contestation. The variation among jurisdictions in procedural protections means that preventive confiscation systems cannot be evaluated as a single monolithic category, but must be assessed individually based on the specific protections each system provides. Looking forward, the legal landscape surrounding firearm regulations will continue evolving, as courts apply refined analytical frameworks to pending challenges. Lower courts now possess clearer guidance about how to conduct historical analysis, reducing the inconsistency that previously characterized judicial decision-making in this area. This increased clarity will likely accelerate resolution of pending cases, as courts apply uniform methodologies rather than struggling with foundational analytical questions. However, increased methodological clarity doesn't automatically resolve substantive disagreements about how historical evidence should be weighed, or which modern regulations find sufficient historical support. The trajectory of constitutional jurisprudence in this area reflects broader questions about how legal systems balance fidelity to founding principles with adaptation to changing circumstances. Strict originalist approaches risk rendering constitutions inflexible documents, unable to address modern challenges, while overly flexible interpretive approaches risk untethering constitutional meaning from any fixed principles. The challenge lies in identifying the appropriate level of abstraction at which to identify historical principles, extracting enduring values from specific historical applications, while remaining faithful to the constraints those founding principles impose. This balancing act will continue generating controversy, precisely because reasonable people disagree about where appropriate lines should be drawn between principled flexibility and unprincipled revisionism. The coming years will test how various regulatory approaches fare under increasingly uniform judicial scrutiny. Some restrictions will likely survive constitutional challenges by demonstrating sufficient historical grounding or by targeting conduct genuinely incompatible with responsible citizenship. Other restrictions may fall because they lack historical support or because they burden conduct that millions of law-abiding citizens routinely undertake without incident. The outcomes will depend on how courts apply general principles to specific factual contexts, a process that inevitably involves judgment calls about which historical evidence proves most relevant, and how closely modern regulations must track historical practice. Understanding these developments requires moving beyond simplistic narratives that portray judicial decisions as purely political outcomes divorced from legal reasoning. Courts operate within analytical frameworks that constrain decision-making, even when those frameworks leave room for disagreement about specific applications. The recent refinement of methodological approaches represents genuine attempts to develop workable standards for resolving difficult constitutional questions, not merely results-oriented reasoning designed to reach predetermined conclusions. Recognizing the analytical work courts perform helps illuminate why particular outcomes emerge and what future developments might reasonably be anticipated. The transformation of constitutional analysis in this area ultimately reflects deeper questions about the nature of rights, the scope of government authority, and how societies balance competing values. These questions lack easy answers because they involve genuinely difficult trade-offs between individual liberty and collective security, between constitutional fidelity and policy innovation, between judicial restraint and active rights protection. The ongoing evolution of legal doctrine represents sustained engagement with these fundamental questions, with courts gradually developing more sophisticated frameworks for addressing tensions inherent in constitutional governance. Whatever one's views on optimal policy outcomes, the judicial process of reasoning through these difficult questions deserves serious engagement, rather than dismissive characterization as mere politics by other means.